In the Trump v. Anderson case, it tests whether the 14th Amendment, Section 3, which prohibits an office holder who has engaged in insurrection or given aid or comfort to those who have, whether that individual can serve in office again. The 14th Amendment, Section 3 says that they cannot. The 14th Amendment was and is a Reconstruction Amendment. And what the members of Congress at the time understood is that the 13th Amendment did not go far enough in securing the kind of country that the Constitution is inspired to create. And therefore, we have equality, substantive due process, privileges and immunities being forged in the 14th Amendment. And then it comes to this space that now is of such critical importance to us today, and people are struggling to understand, well, why is it that there's a Section 3? Well, there's a reason for this. And the reason for this is that in Congress, leading up to the 13th Amendment, you have members of Congress who've run on a platform as radical Republicans who are interested in ending slavery. They fight for this. They write about this. They give speeches in Congress. These members are also subjected to violence that has not often been talked about. Famously, Charles Sumner, the senator from Massachusetts, is caned nearly to death. So when we think about a Section 3, one must understand that they understood because they had experienced violence. They knew that printing presses had been blown up and so much more just in trying to end slavery and to forge a more perfect union. In the Trump v. Anderson case, there are a number of arguments that the former president's legal teams are making. The first is that the former president has articulated that he had a First Amendment right to question the results of the 2020 presidential election. The former president has also made arguments that suggest that the language in the 14th Amendment, Section 3, does not apply to him, that it doesn't spell out that it applies to a president. Third is that the former president and his legal team have made arguments across a series of cases, including in Colorado, and that is absolute immunity. Those legal teams have also said that this applies for any past president, sitting president, or future president. But here's what we understand about that. There are no absolutes in the Constitution and no absolute protections. There's not even an absolute First Amendment right. There are time, manner, and place exceptions there too. Now, what does that mean for this United States Supreme Court? It's hard to guess. What makes this complicated is the fact that in recent years, this is a court that has leaned into what is called originalism. Well, if the court does that, and it thinks about those times of the past when the 14th Amendment was then ratified and the deep concerns about the potential for the Union to be affected by rogue actors who are unwilling to abide by the rules of our Constitution and a unified government, then they were clearly thinking about a time like this.